while the Honorable Chief Justice of the Philippines and the Associate Justices of the Supreme Court of the Philippines are now entering the virtual session hall. Hear ye, hear ye, hear ye. All persons having business before the Honorable Supreme Court of the Philippines shall now take their attention, for the court is now in session.
Your Honors, good afternoon. This is a continuation of the oral arguments on the 37 consolidated petitions assailing the constitutionality of Republic Act number 11479 or the Anti-Terrorism Act of 2020.
Appearances.
May I request the 7 presenting lawyers for the petitioners and the counsels for the respondents to make their respective appearances.
Good afternoon, Your Honors. Attorney Howard M. Calleja for GR number 252578, Calleja et al. Versus Executive Secretary Eddy, Your Honor.
Good afternoon, Your Honors. Edsel Silagman, same appearance in GR number 252579. Thank you, Your Honors.
Good afternoon, Your Honor. Attorney Darwin Angeles, respectfully appearing for petitioners, Justices Tonio T. Carpio, Conchita Carpio Morales, and UP Law professors in GR number 252736. Ready, Your Honor.
Good afternoon, Your Honors. Attorney Camille Ross Parpan, together with Attorney Michael Christopher C. De Castro of the Free Legal Assistance Group, respectfully appearing as counsel for petitioners in GR number 252741.
Attorney Ursua. Counsel for 252747. Mukhang nag-freeze si Attorney Ursua. Okay. Counsel for 252759.
Good afternoon, Your Honor. Assalamualaikum. I'm Attorney Bantuas Lokman, together with me, Attorney Musa Malayang, appearing as counsel in GR number 252759. Thank you, Your Honor.
Next.
Good afternoon, Your Honors. I'm Attorney Randall Sitabayoyo, appearing as counsel for the petitioner, Integrated Bar of the Philippines and its Board of Governors in GR number 253124.
Okay. Is Attorney Ursua available now?
Attorney Ursua, are you there?
Anyway, appearance for the respondents.
Good afternoon, Your Honors. Appearances for the respondents are the following: Assistant Solicitor General Marisa de la Cruz Galandines, Assistant Solicitor General Bernard Hernandez, Assistant Solicitor General Rex Bernardo Pascual, Assistant Solicitor General Raymond Rigodon, Assistant Solicitor General Diana Castañeda de Vera, State Solicitor Eduardo Poquis, and Associate Solicitor Dominic Clavano, Your Honors.
The court recognizes the appearances of the Amici Curay, Chief Justice Renato Espuno, and Retired Justice Francis H. Hardilesa. The session this afternoon is for the continuation of the interpellation of the justices on the respondents. Justice Rudin, please proceed with your interpellation.
Thank you, Chief Justice. Can I call on ASG Regodon to ask some queries about Section 4 of the APA? ASG Regodon.
Good afternoon.
Regodon. Yeah. In the definition of terrorism under the APA, one of the specific purposes mentioned as constituting terrorism is to provoke the government or any international organization. Am I right?
Yes, Your Honor.
Now, this purpose is unique as the phrase to provoke is only found in our APA and not in the anti-terror measures of other jurisdictions. The nearest to this phrase are that specified in the anti-terror measure of Australia, that is to coerce the government of Australia, and that of UN Security Council Resolution number 1566, that is to compel a government or any international organization. Another phrase similar to this is to provoke not a government but a state of terror in the general public. In other jurisdictions, the words commonly used are compel, coerce, force, influence the government, but never to provoke the government. ASD, what do you understand by the phrase to provoke?
To make the government to do something outside the legal processes, Your Honor.
That is compelling. To force to do or not to do something.
Yes, Your Honor.
To provoke is just to stimulate a strong or unwelcome reaction like anger. Am I right? So there is a very big difference between provoking and compelling or coercing. Now, ASD, which is the more repulsive act? To provoke the government or to compel, coerce, or force the government as found in the UNSC resolution and the other anti-terror measures of Australia and several countries. Can you explain this?
So your question, Honor, is whether or not
act to provoke the government or to compel or coerce or force the government as found in the United Nations resolution or the anti-terror measure of Australia and several countries.
Coerce, Your Honor, because there are certain there may have been previous instances where terrorist acts were committed without compelling the government to do something. In which case, if the definition of the purpose of committing that act must have for its purpose to compel the government, there may be instances of terrorist attacks which will not be punished because of the term used or the word used in defining the crime of terrorism. So, to provoke is more broader, and it addresses terrorist acts where there is no demand to the government to do something.
Let us cite an example. Olgen. Assuming that an actress put up a community pantry during an MECQ without regard to COVID protocols and social distancing, thus endangering the lives of people, and at the same time announcing through a megaphone that it is for all the citizens of the Philippines who have been neglected by the government. Can you consider her acts as provoking the government?
No, Your Honor, because that is expressing a grievance against the government, Your Honor, and it's a protected act, Your Honor.
Okay, so there is no probable cause to arrest her for committing an act of terror under the ATA.
Yes, Your Honor.
But that is also provocation. Am I right?
The provocation must be accompanied by an overt act and the intent mentioned in Section 4A to C for it to be considered punishable under Section 4, Your Honor.
So you are saying that it is not provocation because of the exclusion under the last paragraph of Section 4. You are applying Section 4, last paragraph of Section 4. Am I right?
Your Honor, if it is only a provocation, but the element of overt act coupled with intent that is mentioned in the first part of Section 4 are not present, then even if it is considered a provocation, it cannot be punished under Section 4, Your Honor.
So you're saying that the intention of the actress is material in this case?
Yes, Your Honor, because the 4 is
okay.
there, Your Honor.
How about if the person, for example, is a member of Akbayan? Would your answer be the same?
Yes, Your Honor, if the other elements are not present, Your Honor.
Okay, then ASG Ricudon, how do you measure provocation of the government as to constitute an act of terror under the ATA? Can it be merely the slightest provocation?
The provocation here, if I may give an example, Your Honor,
so,
a group of persons bomb, let's say, a public market, causing death to thousands of people, and the purpose of that is to provoke the government, for example, to make reprisals that would inflame the already hostile environment in that locality. And the purpose of the provocation is to bait the government into doing something that those responsible for the terrorism could capitalize in, for the purpose, for example, of recruiting members into their organization, citing the alleged abuses committed by the government in reaction to their terrorist attack, Your Honor.
It would appear that would be compelling, coercing, or forcing the government to do an act, just like the phrase used by other jurisdictions. It's not merely provocation. Now, if you think, why did you not use to modify provocation serious, just like seriously undermining or seriously threatening, seriously intimidating? Why no modifier for in using the word provocation here in the ATA?
I think it goes into the wisdom of the law, Your Honor.
So you're saying is that it is the wisdom of Congress.
Yes, Your Honor.
So I'll ask you now, the wisdom of the Congress, why Congress decided the use of the phrase to provoke and be different from the anti-terror measures of other jurisdictions, which use coerce, compel, and force the government? Do you know the wisdom of the Congress in doing so?
I think, Your Honor, because not all terrorist groups have concrete political goals. Not all terrorist attacks are followed by a list of political demands. Therefore, it may explain for the use of the word provoke instead of compel. And in comparison to the previous anti-terrorism law, where the purpose is to coerce the government into an unlawful demand, um, that uh, that requirement under the HSA made it difficult for law enforcement to file cases against terrorists who do not make any such demand, Your Honor, against the government. That is why, instead of including uh, including as purpose in the definition of terrorism the requirement that there must be an unlawful demand against the government, uh, the the Congress enumerated purposes that are not as limiting as that under the Human Security Act, Your Honor.
What I fear about is that the phrase provoke the government is so vague so as to include any kind of provocation. It did not say that to provoke the government to do or to abstain from doing an act. Just it stated that to provoke the government. So am I right, ASG? It just stated that the purpose is to provoke the government.
If we read the succeeding phrase or influenced by intimidation the government, we can give this we can apply the statutory construction of eius dem generis. So we can define the word provoke by the phrase following it. So I don't think by using the word provoke, it renders this purpose as vague, as impermissibly vague, Your Honor.
You explain this in your memorandum.
Your Honor.
Because it appears that by intimidation is the modifier for the word influence the government. It's not a modifier for the word provoking the government.
Yes, Your Honor. We can discuss that in the memorandum.
Okay. So you made mention also in our discussion on the last paragraph of section 4, which excludes from the definition of terrorism advocacy, protest, dissent, and other exercises of civil and political rights. To inform you, these exclusions are also part of the anti-terror measures of Australia, Canada, South Africa, among others, but not in the anti-terror measures of the United States and the United Kingdom. You know that?
I'm not aware of that, Your Honor.
Do you think that our APA, our law, is better by including this paragraph than be silent on the exclusions like that of the US and the UK?
Yes, Your Honor, because it affirms the commitment of the government to the observance of civil and political rights, Your Honor.
You're correct. But despite these exclusions, the law creates an exception to the exception. What is the exception?
If the exercise of the civil and political rights are intended to cause death, or can I rephrase that, Your Honor? The terrorism as defined in this section shall not include advocacy, protest, etc., and other similar exercises of civil and political rights which are not intended to cause death or serious physical harm to a person, to endanger a person's life, or to create a serious risk to public safety.
What is the position of the OSG on these exclusions? Are these merely matters of defense in the prosecution of terrorism?
Your Honor, our position is that the exercise of civil and political rights is a matter of defense, Your Honor.
It is a matter of defense.
Yes, Your Honor.
It is a matter of defense. Where can you raise it? Can you raise it at the time of arrest or during the trial for terrorism?
Your Honor. Because the prosecution must also be given a chance to rebut the claim that the act was in the exercise of a civil or political right, Your Honor. The prosecution is also entitled to due process of law.
Can I read to you the rule? The rule says that advocacy, dissent, protest, exercises of civil and political rights are not acts of terror. Yes?
Yes, Your Honor.
The prosecution proves the intent to commit the crime of terrorism. Yes?
Yes, Your Honor.
So the general rule is that advocacy, dissent, protest, and exercise of civil and political rights are not acts of terror. They are not matters of defense to be raised. It is the prosecution which has the burden to prove that they are acts of terror. That is under the ATA. And for example, you said a while ago that this actress who puts up a community pantry, any criminal offense which occurs in the course of advocacy, protest, dissent, or exercise of civil and political rights, the prosecution has the burden to prove that there is terrorism. It is not a matter of defense. The general rule is that it is not an act of terrorism under the law. Do you agree with me?
Our position, Your Honor, is that at the initial presentation of evidence, the prosecution did not show that the act is not a valid exercise of a civil or political right. Because when it's the turn of the defense may raise, it is possible the defense may not raise this defense of exercise of civil or political right, but it may raise the defense that the accused will just deny or claim that he was in another place when the act imputed to him took place, and therefore the prosecution has no obligation to anticipate what defense may be put up by the accused. Therefore, in establishing its case, the prosecution has only the initial duty of establishing the overt act, the intent, and the purpose. Now, when it's the time of the accused to present evidence, he or she may raise a defense that he or she is merely exercising his or her political right. Or he or she may raise a defense of mistaken identity. That is also available to
the purpose of Rule 4.4 of the IR, which says that the prosecution has the burden to prove that it falls under the exception to the exception. So for example, in our case of the actress, under the circumstances, you can arrest the actress immediately. It is up to the actress to raise the defense that it is an exercise of civil and political rights. Am I right?
Yes, that's a matter of defense, Your Honor.
So we go to another point. Going now to Section 9 of the APA. Is this still your subject, ASG Rigodon? Section 20. The Solgen maintains that the period of detention without lawful warrant of arrest is a policy determination of Congress. Am I right?
I'm sorry. Are you referring to Section 29?
Yes, Section 29.
Which is question to ASG Galandines. That is the topic assigned to her.
Okay.
Thank you, Your Honor.
Good afternoon, Your Honor.
Good afternoon, ASG Galandines. So, you have said previously that the period of detention without a lawful warrant of arrest for the maximum of 24 days is a policy determination of Congress. Am I right?
Yes, Your Honor.
And what is the reason why the Congress has stated or included therein the period of 14 days extendable by another 10 days for purposes of extended detention?
Your Honor, could you kindly repeat the question? Why was it that Congress included?
Yes. Do you know the reason why the Congress extended detention under the ATA as an exception to Article 125 of the Revised Penal Code?
Yes, Your Honor. There are difficulties or limitations in during detention that would lead to the filing of the information before the proper judicial authority. That is why the Congress deemed it wise to add additional days to the ordinary period of detention provided for by Article 125 of the Revised Penal Code.
Okay. Can you state any law in the past which authorized detention without a warrant of arrest for a period more than that provided for under Article 125 of the Revised Penal Code? Any law in the past, Counsel? This is the first time that a law has extended Article 125 of the Revised.
No, Your Honor. I am trying to...
Well, you may be referring to Presidential Decree number 1936, dollar salting.
Yes, Your Honor.
So, authorized detention for a period not exceeding 30 days before delivery of detained to the judicial authorities. Am I right? That reason is the same as that of the ATA. That is because of the complexities of dollar salting or dollar blackmailing, which may not warrant the early filing of information in court. Now, do you know the basis of the Congress in deciding on the period of detention for 14 days, extendable by 10 days, and not 30 days considering the unique nature of terrorism, or even 59 days of detention, just like in Malaysia, or 730 days of detention, just like in Singapore? Do you know why the Congress opted to put the period of detention for only a maximum of 24 days?
Your Honor, from the deliberations, we gathered that the said period of detention of 24, Congress, in its wisdom, set the limit of 24 days because of various opposition to the increased number of days. In order to meet the challenges of the different oppositions to the increasing detention days, Congress, from the deliberation, we found that Senator Lacson, the principal author of the law, agreed to a maximum period of 24 days.
So this is a policy determination of Congress, this particular period of not more than 24 days.
Correct, Your Honor.
Is the court powerless to strike off this period of detention under the Constitution?
Your Honor, we submit that this is a political question that is not subject to judicial scrutiny, Your Honor.
So any person cannot go on certiorari to the Supreme Court on grave abuse of discretion to question this particular maximum period provided under the law?
Your Honor, it is our submission that This is a policy or wisdom of the legislature, branch of the government, and therefore this is a political question not subject to judicial scrutiny, Your Honor.
Thank you, Counsel. Now, upon questions of Justice Rory Carandang, you have said that an enforcement agent or military personnel needs no prior written authorization from the ATC before he can make an arrest without warrant. Is this correct?
Yes, Your Honor, under Section 29 of the ATA of 2020, yes, Your Honor.
And also Rule 9.2 of the IRR, which
Yes.
states that the law enforcement agent may arrest without a warrant.
Correct, Your Honor.
The ATA and the IRR speak only of a law enforcement officer or military personnel. Am I right?
Correct, Your Honor.
Does it mean a private person has no authority to make an arrest under the ATA? The ATA and the IRR speaks only of a military personnel or a law enforcement agent.
Your Honor, Section 29 is detention without warrant of arrest. And under Rule 113, anyone can make a warrantless arrest as long as any of the circumstances provided for under Rule 113 is present. Citizen's arrest is not prohibited, although Section 29 speaks only of a law enforcement agent or a military personnel. It is our submission, Your Honor, that citizen's arrest is not prohibited.
Because of Section 5, Rule 113 of the Rules of Court.
Yes, Your
Rules of Arrest.
Yes, Your Honor.
This is not found in the ATA or in the implementing rules and regulations. Am I right?
Correct, Your Honor. But we submit just the same, the citizen's arrest is not prohibited.
So, Counsel, regarding the written authorization issued by the ATA, or the ATC rather, is the written authorization to detain issued for not more than 24 calendar days automatic?
No, Your Honor. It is not automatic, Your Honor.
What is required first before ATC issues a written authority?
Your Honor, three things must be established: that the continued detention is warranted, continued detention is required to preserve the evidence already gathered, and the investigation is being conducted properly or in order, Your Honor.
And what is the most important requisite which you did not mention?
Detention is necessary to prevent evidence related to terrorism. Detention is necessary to prevent the commission of another terrorism. Detention is necessary. Investigation is being conducted in an orderly manner, Your Honor.
The most important requisite is that the one detaining the person should submit a sworn statement or justification to the ATC before the ATC can act on issuing a written authority. Am I right?
Yes, correct, Your Honor. Correct, Your Honor.
If, for example, the person in custody refuses to issue a justification or a sworn statement to the ATC may not issue a written authority. Am I right?
Correct, Your Honor.
The ATC cannot issue motu proprio, a written authority for extended detention.
No, Your Honor, because requisites must be established.
So the ATC cannot also issue a blanket authority of detention. Am I right? There should be a justification or a sworn statement submitted.
Correct, Your Honor.
So from this discussion, it would appear that the detention should be in compliance with Article 125. That is, the detention should only be for a maximum of 36 days. Am I right? Unless the custodian submits the sworn statement or justification to the ATC.
Correct, Your Honor.
So the general rule is still Article 125 of the REC.
Correct,
And
Your
EC cannot issue motu proprio a written authorization.
Correct, Your Honor. Following the valid warrantless arrest, if the military personnel or the law enforcement agent is convinced that there is that there is cause to file an information for violation of ATA, even within 12 hours, he could bring the arrested individual to the nearest judicial authority, Your Honor.
So if there is no written authority given by the ATC to the custodian, can the custodian file a case under the ATA?
Your Honor, within the original period, yes, Your Honor.
Within for acts of terrorism within the original period?
Yes, Your Honor.
Withstanding the fact that the ATC did not issue that written authority.
Yes, Your Honor. If the law enforcement agent or the military personnel is convinced that the case for violation of the ATA will stand, then he could file the case within the first 36 hours, Your Honor. And in this manner, there is no need for an ATC authorization to file the complaint affidavit, Your Honor.
Counsel, do you know that under the ATA and the IRR, there is no duty imposed on the custodian of the suspected terrorist to submit a sworn statement or a justification to the ATC? The custodian is not mandated to do that, to submit the sworn statement or justification. Please go over the law.
Your Honor, our submission is that the law enforcement agent or the military personnel must justify the continued detention by submitting a report to the ATC, Your Honor.
Can you read the ATC, the law?
I will. Or by Your Honor. Shall without the provisions of Article 125 of the revised penal code to the contrary notwithstanding, any law enforcement agent or military personnel who, having been duly authorized in writing by the ATC, has taken custody of a person suspected of committing any of the acts defined and penalized under sections 4, 5, 6, 7, 8, 9, 10, 11, 12 of this act, shall without incurring any criminal liability for delay in the delivery of detained person to the proper judicial authorities, deliver said suspected person to the proper judicial authority within the period of 14 calendar days counted from the moment the said suspected person has been apprehended, arrested, or detained, and taken into custody by law enforcement agent or military personnel. The period of detention may be extended to a maximum period of 10 calendar days if it is established that further detention of the person is necessary to preserve evidence related to terrorism or complete the investigation. Further detention of the person is necessary to prevent the commission of another terrorism, and the investigation is being conducted properly and without delay.
So, Counsel, both Section 29 of the ATA and Rule 9.1 of the IRR they do not impose any duty on the part of the custodian to submit a sworn statement or justification. You can go over and over the law and you will not find the duty imposed upon the officer. Let's go to another point. counsel. If no written authority, for example, is given by the ATC to the law enforcement agent upon submission of a justification or sworn statement for an extension of detention. Now, but notwithstanding this lack of written authority, the custodian continues the detention of the suspected terrorist. What is the remedy of the suspected terrorist?
Since under the IRR, the ATC shall issue a written authority in favor of the law enforcement officer or military personnel upon submission of a report if the law enforcement authority or the military personnel continues with the detention without authority from the ATC, then he may file a petition for the issuance of habeas corpus. However, in this case, he has the burden of proving that the arrest is illegal, Your Honor.
So if no authority is issued by the ATC and a continuous detention is taking place, it is still the suspected terrorist who has the burden of proof to prove that the arrest is illegal.
Yes, Your Honor. He has to prove that the law enforcement authorities failed to establish that there is evidence obtained from him in relation to terrorism which must be preserved, justifying his continued detention, or that the investigation being conducted on his person is not properly that the investigation is not properly handled, Your Honor.
But under the circumstances, the detention is already beyond Article 125 of the revised penal code. So the suspected terrorist has still to prove that the detention is illegal or unlawful, as what you have said.
Your Honor, Your Honor, may I clarify my answer? If the detention is beyond the period provided for by Article 125 of the revised penal code, and the law enforcement agent or the military personnel fail to secure written authority for the continued detention from the ATC, consequently, the person arrested must be released as there are other lawful grounds for his continued detention. Otherwise,
if, for example, the custodian won't release that suspected terrorist, the suspected terrorist has to prove that there is illegal detention still?
The law enforcement agent or the military personnel would be subject to administrative charges already, Your Honor, if he fails to release after the lapse of the period provided for under 125 of the revised penal code, and his continued detention is without the authority of coming from the ATC, Your Honor. He must, otherwise he must to face administrative charges, Your Honor.
So the remedy is to file a petition for a writ of habeas corpus under
yes, Your Honor.
Okay. Now, for example, after 36 hours of detention, but before filing of that information in court, the ATC belatedly issues the written authority. Will this justify the continued detention of the suspect? So 36 hours has already lapsed. Then in the 48 hour, the written authority comes in. Will this justify the continued detention of the suspect?
It is our submission, Your Honor. This will depend on the circumstances, but preliminarily, our submission is that there is nothing more to extend. If the ATC will give its authorization after the lapse of 36 hours, then this there is nothing more to extend to.
I agree with you, Counsel. Let's go to another point. In section 29 of the ATA, we see there is a duty on the law enforcement agent or military personnel who is in custody of the suspected terrorist to immediately notify in writing the judge of the facts and circumstances of the arrest. And under Rule 9.3 of the IRR, immediate notification is defined as a period not exceeding 48 hours from arrest. Why a period of 48 hours for purposes of mere notification under the IRR when the ATA says immediately after taking custody? Can you explain this to us?
Your Honor, under 9.3, notification must be done immediately.
Yes. But the period says immediate is not exceeding 48 hours from arrest. Is that still immediate? So if you notify, say for example, on the 47th hour after arrest, is that immediate? That is 2 days to be exact from the time of arrest. Is that immediate?
Your Honor, there are instances where the area where the suspected terrorist was arrested is the area is a remote area, Your Honor, and therefore in 48 hours would still fall within the ambit of the term immediate, Your Honor.
With our present communication setup and transportation, 2 days is immediate to you, counsel?
Yes, Your Honor, is provided in the IRR that
because it is provided in the IRR, immediate is 48 hours.
See, Your Honor.
Okay, now.
Honor, we admit that this would depend on the area where the suspected terrorist was arrested, Your Honor.
We go to another point. So, under Article 125, it requires only, it is mandated that the custodian should deliver the person in custody to the judicial authorities within the 36-hour period, maximum of 36 hours, not 48. Am I right?
Yes, Your Honor. 12, 24, 36. Yes, Your Honor.
Yes. And because of this, there is a possibility that an information has already been filed in court or the suspect has already been released before the notification is made to the court about the arrest. Isn't that absurd?
Again, Your Honor, we submit that the 48 hours provided for under the IRR is really dependent on the area of the arrest. And again, we respectfully submit, Your Honor, that 48 hours is covered by the is still immediate for areas for remote areas, Your Honor.
So last question, Counsel Attorney Galandines, ASG Galandines rather, in reply to a question of Justice Rosario, you said that the government is not doing a red tagging, but a truth tagging. That was the first time that I heard about the phrase truth tagging. Can you explain to us the difference between red tagging and truth tagging?
Your Honor, the government does not have a policy of red tagging. For us, truth tagging is a comprehensive and detailed and careful evaluation of facts and circumstances before the government tags a person or organization. Government does a comprehensive and detailed and careful evaluation of facts, as opposed to red tagging, Your Honor, which we submit is not a government policy, Your Honor.
Okay. That's all, Counsel. Thank you.
Thank you, Your Honor.
Thank you, Chief Justice.
Thank you, Justice Rodil. May we call Justice Inting to proceed with his interpellation.
Justice Inting, please.
Okay, yes,
mute.
I'm already unmuted myself. Thank you, Chief. Assistant Solicitor General Marisa de la Cruz Galandines, can you hear me?
Good afternoon, Justice.
Yes, good afternoon, ASG Galandines. Okay, in the last hearing, my esteemed colleagues already went into the nitty-gritty of the constitutionality of the provisions of the Anti-Terrorism Act, or ATA. So allow me to begin my interpellation by turning to the other aspect of this case, specifically the context and some practical aspects of our country's war on terrorism. So my first question is, has the President issued any public statement regarding the implementation of the ATA and full respect for human rights or the Bill of Rights? To your knowledge, because there are already cases filed, no? 3 cases.
Yes, Your Honor. In fact, Your Honor, the Solicitor General is in his opening statement quoted the President when the President did say that kung hindi ka terorista, hindi ka dapat matakot, sa referring to the Anti-Terror Act, Your Honor.
Okay. How about his cabinet officials? Have they given statements regarding this ATA with regard to observation of human rights and the Bill of Rights, if you know?
I
like
am
the SOJ, has he given any statement regarding this?
Your Honor, I'm sorry to remember any statement from the Secretary of State at this moment, Your
How
Honor.
about the law enforcement agents?
I cannot remember as well, Your Honor.
So I'm asking this question is in order that the public will be assured that the ATA will be implemented with full respect for human rights or the Bill of Rights.
Your Honor, please.
Yes.
The ATC in just last April 21, 2021, came up with a report detailing the various focus programs being undertaken by the different departments of the government, Your Honor. We will.
So, can you enlighten us with that? Can you give us an example?
The ATC has taken the lead in developing and publishing a guidebook for law enforcement agents and military personnel. There is also a continuous rollout of training and workshops for our law enforcers. Also, the NICA rather, published a primer of the frequently asked questions on the ATA, and this has been published in their website. Also, Your Honor, the DILG has begun implementation of the National Action Plan on preventing and countering violent extremism, and they have developed modules for barangay-based reconciliation programs. These are just the examples of focus programs, Your Honor, which we will gladly include in our memorandum, Your Honor.
Thank you, ASG Galindines.
Yes, sir.
Now, on another related matter point, prior to the ATA, we had the Human Security Act, no?
Correct, Your Honor.
Would you know the track record of the law enforcement agencies in implementing the Human Securities Act, specifically relative to the full respect for human rights or the Bill of Rights?
Your Honor, if I remember correctly, there was only one successful prosecution under HSA, Your Honor.
So let's move to another related point. I am just curious if you know whether other countries adopted anti-terrorism laws ahead of the Philippines with similar or more restrictive means. Do you know of any country?
Our particularly in Southeast Asia, Your Honor, their periods of detention is longer, very much longer, in fact, than our period of detention provided for under Section 29, Your Honor.
Okay, thank you for that. Now, ASG Galindines, let us go into the specifics of the ATA. I recall you were interpellated at length by my esteemed colleagues on the nature of the functions of the ATC under the ATA, correct?
That is correct.
Yes. And I also recall you are very firm on your stance that the ATC performs purely administrative or executive functions. Am I correct?
That is correct, Your Honor.
Now, under Section 25 of the ATA, I recall that you firmly maintained during the last hearing that the power to designate a person or group as a terrorist is merely an administrative function or power.
That is
to say that?
That is correct, Your Honor.
So my question is, in making such designation, would the ATC need to determine questions of fact relative to the policy and standards laid down by the ATA in defining terrorist groups and or terrorism itself?
The ATC, when it designates groups, individuals, group of persons, organizations or associations, domestic or foreign, does the same upon finding of probable cause, Your Honor.
So you will have to determine the factual milieu of the arrested persons.
That is correct.
Not automatic giving a written authority for detention.
Your Honor, probable cause that under Section 25, probable cause that the individual, group of persons, organizations, or association commit or attempt to commit or conspire in the commission of any of the acts defined and penalized under Sections 4 to 12 of the ATA of 2020, Your Honor.
Okay. Thank you, ASG Galindez. I think that will be my only questions. Apparently, a lot of questions have already been asked of you. So, Chief, I'm done.
Your Honor.
Thank you.
Thank you, Justice Ginting. Justice Mon Hernando will interpellate the Respondents' Counsel.
Chief, I don't have any questions for the government.
No questions.
I have no questions, Chief. Thank you.
Okay. Thank you, Justice Mon. May we call Justice Marvick Leonen to proceed with his interpellation. Oh, Justice Kagiwa first. Sorry. Justice Kagiwa. Is Justice Kagiwa. Justice Ben.
Chief, I think Justice Ami precedes me first.
Oh, sorry about that. Yeah, Justice Ami.
You, Mr. Chief Justice. Thank you. Okay. Can I have Mr. Assistant Solicitor General Rigodon first?
Good afternoon, Your Honor.
Good afternoon, ASG Rigodon. You're not nervous anymore. This is your third time being interpellated by the court. Okay? Less anxious, more confident, and less afraid. Okay. ASG Rigodon, many of the petitioners, including their respective counsel, are bona fide members of the bar. Two of them are former members of the court who to this very date hold our highest respect and admiration. They are our compatriots whose love for this country like ours cannot be measured. They assert that instead of assuring our people protection, security, and safety, the anti-terror law triggers fears of massive rights abuses in view of what petitioners refer to as the grant of excessive and unchecked powers to the state under the law. That the law is a legalized form of capital punishment that can be inflicted anytime by one trigger-happy law enforcer or military officer. What is the government's position on this?
The assertions of the petitioners are highly speculative, Your Honor. And jurisprudence teaches us that assuming that there is a possibility of abuse in the implementation, such possibility is not a ground to invalidate the law, Your Honor.
Okay, very well. If the government says that fears and apprehensions are merely speculative, then baseless, what has the government done to allay the fears, the apprehension, the suspicion and feeling of repugnance of the public toward the ATL?
For one, Your Honor, in his opening statement, the Solicitor General pointed out that the government is not the enemy here, but the terrorists, Your Honor. And as ASG Galandines stated in response to the question of justice in Ting, President Duterte told the public that if you are not a terrorist, you have nothing to fear.
All right. Is that enough?
Is
that enough to allay the fears, the apprehensions, the suspicion, and repugnance of the public toward ATL? Is lip service enough?
Under Section 2 of the ATA, Your Honor, the state recognizes that the fight against terrorism requires a comprehensive approach comprising political, economic, diplomatic, military, and legal means, duly taking into account the root cause of terrorism and/or criminal activities. Such measures shall include conflict management and post-conflict peace building, addressing the roots of conflict by building state capacity, and promoting equitable economic development, Your Honor.
All right. Please pardon me, but I think the answer is not responsive to my question. So please, I have no time to debate with you on this. So please present this in your memorandum. All right. I go to the next question. The definition of terrorism under Section 4 of the ATL heavily relies on intent, which is a state of mind. The ATL tasks the law enforcement officers and military personnel to a certain intent based on nature and context. But one law enforcer's reading of a situation's nature and context may differ from that of another. Without any definitive criteria or guide on how to read nature and context, law enforcement officers may have different ideas as to what constitutes terrorism. So what has the government done or is doing to ensure that the members of the police and the military will not have varying interpretations and understanding of the ATL?
As manifested earlier by ASG Galandines, the ATC has released guidelines for law enforcement and military personnel with respect to the implementation of the ATA, Your Honor.
Is the issuance of these guidelines enough, considering that the law enforcers, most of them are non-lawyers, and the ATL is such a technical and legal thing? How does the government assure the people and make sure that the understanding is one and the same, so that we will avoid the misimplementation of the ATL? Does the government hold seminars, lectures, or whatever initiatives to ensure that a misimplementation or misunderstanding of the ATL will never occur at the expense of human lives?
Yes, sir. I believe that the ATC will conduct, or I have no personal knowledge on whether has already conducted, but I'm sure that the ATC will consider the conduct of training, will hold seminars for law enforcers and military personnel, Your Honor.
All right, that's all for you, ASG Raymond Rigodon, and thank you very much. Can I have ASG Marisa de la Cruz Galandinas?
Good afternoon, Your Honor.
Good afternoon, ASG Marisa de la Cruz Galandines. Would you agree that when a law enforcer or military officer goes to the ATC for purposes of securing a detention authority, he or she ought to be already armed with some kind of evidence for the ATC's evaluation?
Yes, Your Honor.
Yes. Otherwise, there is nothing for the ATC to process.
Correct, Your Honor.
Now, does the law provide specific parameters or standards to be applied by the ATC in evaluating the evidence and in deciding whether to grant applications for detention authority?
The law enforcement agents or the military personnel must be able to convince the ATC and present probable cause that the continued detention of the detainee is needed, so that further terrorist acts could be prevented.
Yes.
That the continuous detention is necessary to preserve the evidence, and that the detention and investigation is being conducted in an orderly manner, Your Honor.
Yes. You were speaking of the extension.
Yes, Your
right?
Honor.
And the law specifies the standard probable cause. I am asking you about the initial grant of detention authority. What is the standard imposed by the law, if any?
Your Honor, we submitted its probable cause, Your Honor.
Why? Is it specified in the law, just like how the law specifies that probable cause for extension is the standard to be followed?
It is not specified in the law, Your Honor, but we submit that it is probable cause because said suspected person, to justify the continued detention of said suspected person, Your Honor, without incurring any criminal liability.
Yes, you're again speaking of the extension. We're on the same page, aren't we?
I
was speaking of the initial grant of up to 14 days, which
Yes.
the law itself does not provide any standard. Okay, so please treat this in your memorandum.
We will do so, Your Honor.
Yes, very well. Is the grant of detention authority ministerial on the part of the ATC?
No, Your Honor. It is not ministerial, Your Honor.
So what are the possible grounds for denying an application?
Your Honor, the ATC
authority
may deny the grant of detention authority if the law enforcement agents or the military personnel could not show that there is a necessity to preserve there was actually no evidence to preserve, or the detention is not the continued detention is not necessary because because it would not prevent the commission of any other crime. So
okay. Again, Madam Assistant Solicitor General, you were again speaking of the extension. And I was asking you about the initial grant or denial of an application for detention authority. I will go to the next question. In cases where a detention authority is sought by a police or military officer following a valid warrantless arrest for the purpose of extending the period of detention up to 14 days, may the ATC deny an application on ground that the warrantless arrest was invalid?
Yes, Your Honor. The ATC may deny.
On that ground?
Yes, Your Honor, because the law enforcement authority has to prove that the detention was by virtue of a valid warrantless arrest provided for under Rule 113 of the Rules of Court, Your Honor.
All right. If the ATC does that, don't you think that is an encroachment of judicial functions to determine whether a warrantless arrest is valid or not?
We believe, Your Honor, that this is not an encroachment of judicial function, Your Honor. After all, it is the ATC, which is mandated by law to extend the period of detention. And it is in consonance with the observance of constitutional rights of the detainee, Your Honor.
The ATC is just an administrative body. Can it validly pass upon the validity or invalidity of a warrantless arrest?
We submit that it can validly pass upon the validity of the warrant of arrest as law because the ATC is with the ATC would have to evaluate if the detention was by virtue of any of the circumstances provided for under Rule 113 for purposes of extension, Your Honor.
Yes, so here is an administrative body that performs a judicial function.
We submit, Your Honor, that this is a mere act of supervision and not an exercise of a judicial function, Your Honor.
All right. Can you point what part of the ATL states that the council can pass upon the validity of a warrantless arrest? All right, I go to the next question. In applications for extension, the law has fixed 3 requirements. Are these requirements cumulative, or each one can stand on its own?
We submit, Your Honor, that it could stand on its own, Your Honor.
You mean to say that it is enough that even just one requirement, the presence of one requirement is enough to seek an extension for detention, extension of detention?
We submit, Your Honor, that the presence of one of the requirements would suffice, Your Honor.
Doesn't the law require the concurrence of these 3 requisites?
It is our submission that it does not require the concurrence of these requisites, Your Honor.
All right. Can you read the law?
It is the period of detention may be extended to a maximum period of 10 days if it is established that for the detention of the person is necessary to preserve evidence related to terrorism, 2, further detention of the person is necessary to prevent the commission of another terrorism, and 3, that the investigation is being conducted properly and without delay.
So does the law state that the presence of only one requirement is sufficient for the purpose of extension?
Let me correct myself, Your Honor. It is that grounds 1 and 3 are present and grounds 2 and 3 are present, Your Honor. It is that the investigation is being conducted in a proper manner and without delay, Your Honor.
All right. So let's take the first requisite. The extension is necessary to preserve the evidence. What do you mean by to preserve evidence? And how is evidence preserved? Why is there a need for additional detention period for this purpose? Are we speaking here of evidence already in the possession of the government, or evidence that is in the possession of a third person that has yet to be obtained by the government?
Your Honor, when we speak of evidence that needs to be preserved, we speak of this pertains not only to case building but also to prevention of the crime of terrorism. The existence of Your Honor, let me rephrase my answer. When we speak of evidence already, when we speak of preserving evidence, it means that this pertains not only to case building, but also to the prevention of the actual crime of terrorism. The existence of these circumstances is best determined by the principal enforcer of the ATA, Your Honor.
All right. So in other words, you're saying that the evidence may pertain to one that is already in the possession of the government and another in possession of a third person, which the government intends to obtain.
That is correct, Your Honor.
Yes. If we speak of evidence already in the possession of the government, why is there still a need to seek an extension for the purpose of preserving evidence?
Your Honor, an example of this is when the law enforcement agents would need to decipher the evidence they already in their possession, like examination of laptops, etc., Your Honor.
But we speak of preserving evidence, not the deciphering of evidence. Deciphering is one thing, preserving is another. Can you cite an example where the government needs to preserve evidence that is already in its possession?
Your Honor, in terrorism, case build-up requires a number of processes. This would include profiling of the terrorist or suspected terrorist, validation of the information, validation of activities committed by said person, Your Honor.
Yes, that is validation. Again, that is one thing. Preserving is another. All right. Now, let's take the second requisite. There exists a possibility that the suspect will commit another act of terrorism. How is it possible that one who is already in detention may still commit another act of terrorism?
Your Honor, the terrorist is the continued detention of the suspected terrorist is crucial so that he could avoid contacting, or he could avoid contact with other co-conspirators, Your Honor.
So is that not the role of the government to guard, to secure the detention prisoner or the suspect? it's already in the that suspect is already in the custody of the government. So can you cite an example when this person is already in the custody of the government, and yet there is still a possibility that that person will commit another crime of terrorism? How is that possible? Can you cite a specific situation that will depict that requisite?
Your Honor, if the arrested individual is into financing of terrorism activities, then Your Honor, even if he is already in detention, financing could still be undertaken, Your Honor.
So how can he continue with the financing if he is already in the custody of the government?
That is the very reason why, Your Honor, his continued detention is necessary, Your Honor, so that he could not do electronic transfer. That is why his continued detention is called for under Section 29 of ATA, Your Honor, of the ATA, Your Honor.
Because he is a financer, and there is a possibility that the financer will continue to finance.
Yes, sir. A concrete example that would come to mind, Your Honor, is the case cited by Senator De La Rosa during the Senate deliberation. He because of the limitations of the period of detention, then they were mandated to release a terrorist who was arrested in Davao City. This was released in Davao City. This terrorist arrested in Davao City was released because of the short period of detention due to lack of evidence. Senator De La Rosa said that in 2016, this same terrorist was seen in an ICC video among those who beheaded their captive, among those who did behead one of their captives, Your Honor.
All right, I go to the next question. Will the suspected terrorist be informed of the application for extension of his or her detention?
Yes, Your Honor.
Yes. So if so, will the suspected terrorist be allowed to present countervailing evidence before the ATC for purposes of proving that the requirements or the requisites for extension have not been satisfied?
Your Honor, he has remedies to question his continuous detention, but he cannot question his continued detention before the ATC.
He has to go to court?
Yes, Your Honor, and the available remedies provided for under our laws, Your Honor.
Yes, so he will be informed of the application for extension of his or her detention. And will he also be informed of the evidence against him in the hands of the government?
Yes, Your Honor, he will be informed.
He will be informed. This evidence will be made available to him.
Yes, Your Honor, because Your Honor, when this suspected individual files a case in court for habeas corpus, his argument would be that his continuous detention is not warranted because there was no evidence taken from him that would warrant preservation, or that his continuous detention is not warranted because his detention is not being conducted in a properly and orderly manner, Your Honor.
All right. So you mean to say that when the detained prisoner or the detained suspect is informed of the application for extension of his detention and allowed to examine the evidence against him for the purpose of the extension. The privileged character of the evidence is already lost. These evidence are no longer confidential. They have been declassified.
Your Honor, it is our submission that he could only obtain this evidence if he files a petition, if he avails of judicial remedies, Your Honor, like a petition corpus, Your Honor.
The government can, the court can compel the government to produce all the evidence that will support its decision to extend.
We believe so, Your Honor.
Yes. And so when the government discloses or makes available its evidence against the detainee, it means that the government can no longer invoke confidentiality or the privileged character of this evidence, being matters of national security.
Your Honor, the government has to prove the validity of the continuous detention of this individual, of the suspected individual, Your Honor, and therefore the government is mandated to justify continuous detention, Your Honor.
Right. So the government has no right to invoke the privileged character of its evidence, and it being a classified information will no longer be true because the government has already made available the evidence against the accused, against the detainee.
Your Honor, we submit that it is not that the government would waive the character of this evidence. It is just that the government can impose security classifications, and the government can invoke, for example, holding the hearing through an executive session, Your Honor, so that the documents would remain to be the classified information. The sanctity of this document will be preserved, Your Honor.
So the classified information will be declassified, okay, in the court, in the eyes of the court, and in the eyes of the detainee.
Your Honor, it is our submission that it is only for the courts. Applicable provisions where there are applicable provisions where security classifications may fall under the exceptions of the right to access.
After all, the court can compel disclosure of state secrets or a privileged communication or matters of national security.
It is a constitutional, the court itself must determine whether the circumstances are appropriate for the claim of the privilege of the detained individual, or in so doing, it could do so only without forcing a disclosure of the very same thing the privilege is designed to protect, Your Honor.
All right, I go to the next question. Designation is essentially the process of identifying a person or group of persons as terrorists. The ATL provides three modes of designation. One is by automatic adoption of the UN Security Council's consolidated lists. Okay. Is there any statement in the resolution of the UN Security Council, specifically Resolution 1373, making it mandatory for UN member states to automatically adopt the consolidated list of terrorists and terrorist organizations designated by the UN Security Council.
We submit that there is, Your Honor.
Where is it?
Your Honor, in 1373, it calls upon all states to find ways of intensifying, accelerating the exchange of operational information, especially regarding actions of movements of terrorist persons. Also, Your Honor, all under paragraph 3 of 1373, Your Honor.
Does that equate to automatic adoption?
Your Honor, it is our submission that 1373 was passed by, this is a UNSC resolution passed under Chapter 7 of the Charter of the United Nations. And this is, and since it was passed under that article, Your Honor, it is binding on all member states, Your Honor.
Binding, mandatory?
Yes, Your Honor, because resolutions adopted by the Security Council acting under Chapter 7 of the UN Charter are considered binding in accordance with Article 25 of the Charter, Your Honor.
All right.
Charter.
The United Nations Security Council itself released a technical guide for the implementation of that resolution. Okay? The technical guide states, among other considerations, it is necessary to consider whether judicial or other remedies that are effective, independent, and impartial are available to persons or entities to challenge decisions to freeze assets. So, does that conform with the position of the government that the adoption of the consolidated list is mandatory and binding upon the state member?
We submit that it does, Your Honor.
Why? Will you agree that there is no specific provision in the resolution that explicitly states that every member state is automatically compelled or mandated to adopt the consolidated lists coming from the UNSC?
Your Honor, it is our submission that since terrorism is a proper subject matter under Chapter 7 of the UN Charter, and since this is a threat to peace, warranting appropriate action from the UNSC, then the resolutions are binding upon all member states, Your Honor.
So why does the resolution itself recognize the availment of effective measures, okay, to question or challenge the freeze assets orders? All right, I go to the next question. Under Section 36 of the ATL, an aggrieved party may, within 20 days from issuance of a sanctions freeze order, may file with the Court of Appeals a petition to determine the basis thereof according to the principle of effective judicial protection. Our ATL itself provides for that. Does this constitute effective remedy within the contemplation of the UN Technical Guide for the implementation of Resolution 1373?
We submit that this is in compliance with said resolution, Your Honor.
All right. So when petitioners presented their case, Professor Ursua shared the experience of her clients who were denied judicial recourse against a freeze order. According to Professor Ursua, her clients received copy of the freeze order only after 20 days had already expired from its issuance. Hence, they were barred from challenging it. Obviously, the issue is this scenario, that the 20-day period for filing a petition before the Court of Appeals is reckoned from the date of issuance of the freeze order rather than from the date of receipt of the freeze order. Do you agree?
Yes, Your Honor.
Yes. Wouldn't this circumstance render sanctions freeze order virtually unassailable in cases where there is delayed service of notice on the concerned individual or organization? In that case, would you still say that there is sufficient remedy under the law for assailing sanctions freeze orders?
We submit, Your Honor, that the aggrieved party may question the matter before the Court of Appeals, Your Honor.
Even beyond 20 days prescribed by law?
Your Honor, the sanction freeze is the power of the AMLC has been recognized and is in pursuance to our country's obligation found under UNSCR 1373.
How are you going to reconcile your statement with the provision of the ATL itself that the remedy before the Court of Appeals may only be availed of within 20 days from issuance of the sanctions freeze order?
Your Honor, the sanctions freeze order found in the ATA of 2020 is merely a reiteration, or this was merely lifted from RA 10168, which is the Terrorism Financing Protection Suppression Act of 2012, Your Honor. The power, and in the power of the power of AMLAC has been recognized, and it is not, and the power of AMLAC found under this Terrorism Financing Prevention and Suppression Act has not been declared unconstitutional, Your Honor. In any case, Your Honor, we submit that this is only applicable to those terrorists internationally designated, the sanctions freeze, and internationally designated and prescribed and included in the international terrorist list. Excuse me, Your Honor.
You know, that's very dangerous. Saying that beyond the 20-day period, the designated or the listed international terrorists, organization or individual may still, beyond the 20-day period, avail of remedies before the Court of Appeals.
The sanction, it is effective until the basis. The sanction freeze is effective, Your Honor, until the basis issuance thereof.
Yeah, it is. It subsists. All right, until it is lifted.
Yes, Your Honor.
All right. So, but then the period for lifting has already expired without the fault of the individual or the organization. So what is the remedy of that person? You're saying that even beyond 20 days, that person can go to court and lift and have the freeze order lifted. That's a very dangerous
Your Honor,
statement from the government.
The process of delisting is always an available remedy, Your Honor.
Delisting is one thing. Lifting sanctions freeze order is another. And the court, the law is clear that it can only be the party can seek its lifting only within 20 days from issuance of the freeze order.
Yes, sir. It is our submission that the sanctions freeze, that the duration of the sanctions freeze is effective until the basis for the issuance thereof has been lifted, Your Honor. And it could be lifted by the process of delisting, Your Honor.
All right. The law prescribes the standard for the government or the ATC to issue an extension, all right, of detention. So it is your position that the same standard of probable cause is also applicable to the application for original detention, for the original period for detention, which is up to 14 days.
Your Honor, may I be clarified, Your Honor? The first period of detention, the first part of the period of detention is by virtue of a valid warrantless arrest and probable cause as ascertained by the arresting law enforcement agent.
Yes.
Yes, Your Honor.
But then, before the expiration of the 36 hours,
yes, Your Honor,
right, the military or the police officer has the remedy to extend it, to have a detention authority issued by the ATC. And at first instance, the first period is up to 14 days.
Correct.
And it's saying that probable cause is the standard to be followed by the ATC in that case. But although the law does not require or impose any standard, unlike the standard for the extension that is up to another 10 days, the law is clear that the standard is probable cause.
Correct, Your Honor.
Yes. So why do you think the law does not impose a standard for the issuance of the original 14 days, but imposes a standard of probable cause for the extension of 10 days?
In the first extension, Your Honor, the law enforcement agent or the military personnel would simply have to justify continuous detention by proving that detention is necessary to preserve evidence. It is necessary to prevent the commission of another terrorism, Your Honor.
Yes, but that is again for extension purposes.
Extension 14 days, Your Honor.
Yes, and you are also applying the same standard for the original grant of up to 14 days, which the law does not provide. All right. Now, on red tagging, you mentioned last time that you do not use the term red tagging because it does not appear in the books of government as an official act. Rather, you mentioned that red tagging is a term coined by the leftist group. That is what I remember.
That is what I said, Your Honor. Yes.
Yes. But isn't it that the act of calling a group leftist a form of red tagging itself?
We submit that it is not a form of red tagging, Your Honor.
All right. So what is the difference between being leftist and being red tagged?
Your Honor, we reiterate that truth tagging involves a comprehensive, detailed, and careful evaluation of circumstances presented to the government about an evaluation of facts, comprehensive evaluation of facts and circumstances before the government comes up with the tagging of a person or or organization.
So is it the government's own coined term, truth tagging?
Yes, Your Honor. This is after an evaluation process which involves objectivity, fairness, impartiality, and is evidence-based, Your Honor.
All right. Though the term red tagging is only popularized recently, this does not mean that the concept or the act of red tagging is new. Every one of us knows what it means. So we readily understood that it means what it means because the government has been doing it before we knew what it was called, which is why it is readily understood in local parlance. Isn't that correct? We all know what the red tagging means, right? We cannot deny. Even the young children know what red tagging is all about. All right. In several social media posts and interviews, the bemedaled spokesperson of the National Task Force to End Local Communist Armed Conflict, or NTF-LCAC, identified certain groups as fronts of the CPP-NPA. These include party list groups such as Gabriela and Kabataan, which had consistently been winning seats in the elections for party lists. Despite their advocacies, programs, and projects, the spokesperson views them as threats to national security. Okay. Meanwhile, by resolution number 12, dated December 9, 2020, the ATC designated the CPP-NPA as a terrorist organization. This was actually preceded by Presidential Proclamation 374, Series 2017, which similarly designated the CPP-NPA as a terrorist organization under the Terrorism Financing Prevention and Suppression Act. Notably, the designation was against the CPP-NPA alone. Kabataan and Gabriela were never mentioned in either the resolution or the proclamation. Does this mean that after all these months of tagging Kabataan and Gabriela as fronts of the CPP-NPA, there is insufficient evidence linking them to said terrorist organizations after all?
Your Honor, may we respectfully state that these are factual matters, and if you would kindly allow us to call on the NSA to enlighten this court about said matters, Your Honor.
All right. I will reserve that question for the Honorable National Security Advisor.
Thank you, Your Honor.
Right. Last session, you claimed that the government does not engage in red tagging, again, but in truth tagging. So before the government says that a person or group is associated with a designated terrorist organization, like the CPP-NPA, it should have evidence in its possession to support this truth claim, should it not?
That is correct, Your Honor.
So, do you stand on your so-called truth claim that Gabriela and Kabataan are fronts of the terrorist group CPP-NPA? You said that.
Again, Your Honor, may we respectfully present the, if we may
yes. So that question again is reserved for the National Security Advisor. Now, has the CPP-NPA been proscribed as a terrorist organization?
CPP-NPA. There is a CPP-NPA. There is a pending CPP-NPA pending prescription process, Your Honor.
So it hasn't been prescribed yet?
Not yet, Your Honor. It is CPP-NPA has a pending prescription proceedings, Your Honor. is the subject of a pending.
There is an actual case already filed for the proscription of CPP-NPA?
Yes, Your Honor. It is pending in RTC Manila, Your Honor.
Yes. So, pending this case, has the government sought its inclusion in the consolidated list of the UNSC?
CPP-NPA, by virtue of ATC Resolution Number 12, dated December 9, 2020, has been designated as a terrorist organization, and it has also been designated as a terrorist organization in the United States of America in 2002, in the European Union also in 2002, in Australia, and in the United Kingdom, Your Honor, and also in New Zealand, Your Honor.
So under the present ATL law, what is the requirement before we as a country can request their inclusion in the consolidated list? Is it enough that they are designated by our local courts? Or does the law require more than designation?
Designation
or prescription?
I am sorry, Your Honor. Designation by virtue of the ATC resolution would suffice, Your Honor.
Would suffice?
Yes, Your Honor.
Designation will suffice?
The CPP-NPA, by virtue of, was a designated terrorist organization in other countries following the designation of the CPP-NPA by the ATC, Your Honor.
So are you saying that the designation is enough to get them listed, included in the consolidated list of the UNSC?
That is correct, Your Honor. Designation would suffice.
Do you have any provision to that effect? All right, I will go to the next question. When the spokesperson gives statements linking a person or group to the CPP-NPA, does he do so in his official capacity as spokesperson, or are these statements simply his personal opinions?
We submit, Your Honor, that these are his personal opinions and not the official position of the government, Your Honor.
All right. Is this spokesperson allowed to voice his personal opinion on matters specifically relating to security, national security? Can he speak up in his personal capacity on whether individuals or groups who have not been designated or proscribed are in fact terrorists?
Your Honor, since he is a citizen of the Republic of the Philippines, he has the freedom of expression. However, Your Honor, he cannot, the government, since this is not the official position of the government, I believe that the OSG in its comment stated that the position taken by General Parlade in social media is not the official position of the AFP nor of the NTF-LCAC, and was not meant to violate the petitioner's constitutional rights, Your Honor.
Has the government ever disavowed his statements?
If I remember correctly, Your Honor, but if the government, through our comment, Your Honor, that through our comment, because in our comment we said that this is not the official statement of the AFP.
You are also a general. You are an assistant solicitor general, and the head of OSG is also a general, solicitor general. You are the lawyer of the government. Are you authorized to disavow the statements of the spokesperson?
Your Honor, again, may we be allowed, may we submit that these are factual matters involving the position of the AFP and the NTF-ELCAC, and we submit that the NSA is in better position to address this matter.
Right? So I reserve that again for the National Security Advisor. Now, in one of his interviews, broadcaster, in one of the TV interviews of the spokesperson, broadcaster Miss Karen Davila asked him, if you really have evidence against the groups you're red tagging, why not take them to court? And this is his response. We don't have evidence, which is why we've just been red tagging them all these years. This is why we want the anti-terror law and its IRR. With this law, we don't need evidence anymore and can attack anyone we want just by calling them terrorists. What can you say about that?
Your Honor, I was not privy to this statement. I do not. May we again ask?
Yes, you can actually check this.
Yes, to answer
you can verify this if he really said this. All right, but it's all over on the postings of social media and even ABS-CBN. Now, do you agree that red tagging is the meta-legal version of proscription and designation?
Your Honor, again, we submit that we do not adhere to nor believe in this.
Yes, meta-legal. Do you have an idea of what meta-legal means?
Yes, Your Honor.
Yes, what does it mean?
We do not subscribe to the fact that red tagging is the meta-legal of prescription and designation, Your Honor.
So what is meta-legal? All right, I'll go to the next question. You mentioned that petitioner Sarate et al., who claim they are victims of red tagging, failed to provide an official document or judicial order to prove that they are indeed being red tagged. But what proof would you need? Does red tagging have to be in a written official document before it can be said to be real or actual?
Again, Your Honor, we submit that the government is not in the business of red tagging, Your Honor. And maybe the NSA will be in a better position to address your question, to expound on these issues, Your Honor.
Yes. All right. So, because of the incidents involving a police lieutenant from Samar requesting from the trial court a list of lawyers who represent communist terrorist group personalities, saying that the request was made in compliance with instructions from higher PNP officials. All right, and even ask for the mode of neutralization, whatever it means. And because not even lawyers, officers of the court are spared from red tagging. And a Mandaluyong judge, for example, was also red tagged in a tarpaulin along EDSA after clearing two activists of charges. The Supreme Court had to issue a strongly worded statement condemning, in the strongest sense, every instance where a lawyer is threatened or killed and where a judge is threatened and unfairly labeled. How does the government react to this statement of the court?
Your Honor, regarding the alleged red tagging of RTC Judge Kisumbing, Your Honor, the government through spokesperson Harry Roque already stated that this incident is under investigation and that he refused to conclude that the judge is being red tagged, Your Honor.
All right. So, Madam Assistant Solicitor General, you did well That ends my interpellation. Thank you for your grace and patience in responding to my questions. You may now go back to your seat. Mr. Chief Justice, I yield the floor back to you. Thank you.
Thank you very much, Justice Ami.
Thank you.
Justice Kadiwa will be the next to interpellate the counsel for respondents.
Thank you, Chief. Can I be heard?
Yeah, we can hear you, Justice Ben.
Can I ask ASG, the girl, Galadines?
Good afternoon, Your Honor. Good afternoon, Your Honor.
Good afternoon. My colleagues have covered a lot of my questions, so my questions now will be they're really just seeking clarification on your position. Do I understand you correctly? Can we go to section 29 of the ATA law? Do you have a copy before you?
Yes, Your Honor.
The title of that section says detention without judicial warrant of arrest, correct?
Correct, Your Honor.
It doesn't say extension of the period of detention. It says detention without judicial warrant of arrest, correct?
Agree, Your Honor.
Now, I'm trying to understand your position. My reading is, and I'm reading the law now, the provisions of Article 125, to the contrary notwithstanding, any law enforcement agent or military personnel, who having been duly authorized in writing by the ATC has taken custody of a person suspected of, etc., etc. Is it your position that that phrase, having been duly authorized in writing, refers only to an extension of the period of detention and not to the arrest?
Yes, Your Honor. That is our position, Your Honor, that the arrest, the valid warrantless arrest, is by virtue of Rule 113 of the Rules of Court, Your Honor, and not by virtue of an authority given by the ATC.
Understood. But do you agree with me that the language of the law itself, just now, the one that I've read, can be understood to mean that the law enforcement agency or military personnel needs to be duly authorized in writing in order to effect an arrest? Just the law itself, no internal rules.
We submit, Your Honor, that it does not call for that interpretation, Your Honor.
It says that the phrase having been duly authorized in writing by the ATC immediately precedes any immediately follows any law enforcement agent or military personnel. And it immediately precedes the phrase has taken custody of a person. Is it not reasonable to interpret this to mean that it is the ATC that issues the warrant of arrest?
Your Honor, we submit that the correct interpretation is that the ATC gives authority only for the extension of the warrantless arrest.
Okay. Now, as counsel, are you counsel for the ATC as well?
Yeah. Yes, Your Honor.
So, do I take it as ironclad that your position is that ATC never will issue a warrant of arrest? Do I understand that to be the position now, even of the ATC?
Yes, Your Honor. That is the position of the ATC. The ATC will never issue a warrant of arrest. The warrant of arrest contemplated by Section 29 is a valid warrantless arrest provided for by Rule 113 of the Rules of Court, Your Honor.
Okay. Therefore, are you saying that the Rule 9, 9.1, 9.2, up to 9.7 of the IRR is your position as well?
Yes, Your Honor. 9.1. Yes, Your Honor. The ATC does not issue a warrant of arrest. Section 29 does not authorize the ATC to issue warrants of arrest.
Yes, and you are relying also on section or Rule 9 of the IRR to support your interpretation of the language of the law, right?
Yes, Your Honor.
Okay. Can I call your attention to the third paragraph of section of Rule 9.1? Can you read that for us?
If the law enforcement agent or military personnel is not duly authorized in writing by the ATC, he shall deliver the suspected person to the proper judicial authority within the period specified under Article 125 of the Revised Penal Code, provided that if the law enforcement agent or military personnel is able to secure a written authority from the ATC prior to the lapse of the periods specified under Article 125 of the Revised Penal Code, the period provided under paragraph 1 of this rule shall apply.
Okay. My reading of this third paragraph is that it speaks of two things to be in writing. The first is the one in the first line. If the law enforcement agent or military personnel is not duly authorized in writing by the ATC and that person effects an arrest, he shall deliver within the periods of Article 125. So as to sidestep the periods of Article 125, the next line talks about a different piece of writing. It talks about a written authority from the ATC extending the period. Is that a wrong reading as from your position?
Your Honor, it refers to the same authority in writing. It is the same, Your Honor. We have the same.
That's not how it's worded. The way it's worded is if the law enforcement agent or military personnel is not duly authorized in writing.
Correct, Your Honor. If the military officer is not authorized in writing to extend the period of detention.
No, that's not what it says. It says he shall deliver. And it's only in the latter part of the paragraph that he talks about an extension.
Yes, Your Honor. If the law enforcement agent or the military personnel is not authorized to extend, then he must deliver the person he arrested by virtue of a valid warrantless arrest to the proper judicial authorities following the period provided for by Article 125 of the Revised Penal Code, meaning the maximum period he could detain that person arrested would be 36 hours, Your Honor.
Okay, I understand what you're saying, but I'm not seeing the language. The language of the law in itself, for me, is vague. It is ambiguous. It is susceptible to two interpretations. The IRR, the third paragraph, seems to support the proposition that the ATC will have to authorize an arrest. So this is something that's important to me. So can you devote some time in your memorandum to explain your interpretation?
We will do so, Your Honor.
All right. My only other question refers to the definition of terrorism. Under section 4, it says when acts are committed, I understand your position already and the position of Attorney Rigodon, that if the exercise of civil liberty is coupled with the intent to terrorize, therefore it is actionable as an act of terror, correct?
Coupled with specific purpose, yes, Your Honor.
Correct. Now, my problem is the language again of the law. It says it creates an atmosphere or spread a message of fear. Do we have any standards in the law that defines what that means? Is there a standard in the law that says blah, blah, blah is equivalent to creating an atmosphere or spreading a message of fear. Is there a standard in the law? There's none. Is there a standard in the IRR?
For Section 4, Standard of Fear, maybe how to address that in our memorandum, Your Honor.
No, but do you agree with me that per your recollection now, there is no such language, right?
Under Section 4, yes, Your Honor.
As well as IRR, there is no such language defining what is an atmosphere of fear. Correct?
Correct, Your Honor.
Okay. To provoke or influence by intimidation the government or any international organization. Again, there is no standard on what constitutes an act that provokes or influences by intimidation, correct?
Correct, Your Honor. Your Honor, may I be allowed to ask ASC Rigodon to answer your queries on Section 4, Your Honor?
Sure.
Thank you, Your Honor.
Good afternoon, Your Honor.
Good afternoon, Attorney. My question is there any provision or any other language in the law that provides a standard for an understanding of what an atmosphere of fear is?
It is not included, Your Honor, in the definition of terms, Your Honor.
What about influencing by intimidation or provoking the government? Is there a definition or a standard?
It is also not included, Your Honor.
What about causing extensive damage or destruction to a government or public facility? Is there a definition or a standard for what constitutes extensive?
There is no definition.
As well as in the IRR, correct? There is no definition?
Yes, Your Honor.
What about extensive interference? Is there a definition or a standard?
The phrase extensive interference is not included in the definition of terms, Your Honor.
All right. Who determines the existence of these standards? Is it the ATC? Or is it the policeman on the ground arresting a person? If the ATC does not issue, according to Attorney Galadines, if it does not determine the authority for a policeman to arrest a person for violation of the anti-terror law, therefore, the decision to arrest based on the provisions of the law rests with the arresting officer, correct?
Yes, Your Honor.
And yet, that person will have no standard to understand what intimidating the general public means, correct?
Yes, there is a rule of statutory construction, Your Honor, that if the intention is not to give a word or a phrase a technical meaning, it should be interpreted in its ordinary meaning, Your Honor.
Correct. So let me ask you, what is your ordinary meaning? What is your understanding of the ordinary meaning of an atmosphere of fear? How many people?
We can refer to, for example, Your Honor, the definitions found in the Webster's Dictionary or Collier's
So
Dictionary.
let me ask you, how many people? Before you can say there's an atmosphere of fear.
My own interpretation is segments. With respect to segment, Your Honor.
Also, actually, that's my other question. What is a segment? of a population? Or what is a segment of the general public? Who determines that? The policeman?
Yes, Your Honor. Because if he will effect a warrantless arrest, Your Honor.
So in other words, if two people are fighting and in his mind that is a segment, he can arrest the person for terrorism.
Two people are fighting.
Two people are marching against the government for redress of grievances. Is that not a segment?
But the purpose is to intimidate.
No, let's say that the purpose is to intimidate, yes. Who determines that that is a segment?
The police officers, Your Honor. If they're they will apprehend by virtue of warrantless arrest, Your Honor.
Correct, but they're apprehending a person on the virtue of a warrant of arrest, a warrantless arrest, because a crime is being committed in front of them, correct?
Yes, Your Honor.
And the crime, according to you, is something that cannot be handled by any standard.
Your Honor.
Your assessment of what constitutes a message of fear or an atmosphere of fear might be different from mine.
But
it might be different with an ordinary policeman, correct?
Yes, Your Honor. But in previous cases, the Supreme Court ruled that the absence of a standard or a definition of a certain term will not render that statute unconstitutional, Your Honor.
Remember, you are depriving a person of a fundamental liberty, a fundamental right to be free. And are you saying that that can be done even if there is no standard? Or if the standard is susceptible to different interpretations? As many policemen as there are who have different interpretations of what a segment is, what an atmosphere of fear is? Is there case law that defines or gives a definition on what an atmosphere of fear is all about?
As far as Philippine law, none that I know of, Your Honor.
Is there case law that says what a segment of the general public constitutes?
None that I'm aware of, Your Honor.
Is there jurisprudence that talks about extensive interference? Is there a definition of what makes an interference extensive or not extensive?
I'm not aware of any jurisprudence, Your Honor.
Same with extensive damage, correct?
Yes, Your Honor.
That's all. Those are my only questions, Attorney. Thank you so much.
Thank you, Your Honor.
I am done, Chief. So we can go to the next one.
Okay. Thank you, Justice Kagiwa. May we call Senior Associate Justice Marvic Leonen to proceed with his interpellation.
Good afternoon, Chief. Good afternoon, colleagues. May I ask who is in charge of judicial review?
Good afternoon, Your Honor.
Good afternoon, Assistant Solicitor General. How are you today? Feeling better?
Fine, thank you, Your Honor. Feeling better.
I hope you still feel better after the interpellations.
I hope so too, Your Honor.
Yes. I am, of course, missing your boss, the Solicitor General. Please send my regards to him if he is around. Now, my first question is, does the threat to terrorism suspend the Constitution?
No, Your Honor, it does not.
It doesn't suspend the Constitution. Does terrorism or the existence of terrorism also suspend the Constitution?
No, Your Honor.
No, it does not suspend the Constitution. Otherwise, we will not be here because then our relevance would be undermined as a court. Because we're not a political body, we stand only because we have the Constitution to implement. Is that not correct? Is that correct?
That is correct, Your Honor.
Yes. Okay. Of course, at the time that the Constitution was being promulgated, this was in 1986. And at the time that the sovereign was weighing the words that were in the Constitution, terrorism did exist in 1986, but it had no specific definition internationally or even within our borders. That is correct.
That is
agree?
Agree, Your Honor.
Yes. But the absence of the existence of the term terrorism, or even the public concept or a unified public concept of terrorism at the time that the Constitution was being ratified, does not prevent us to make use of the Constitution to interpret the various incidents relating to what we now call terrorism in relation to the Constitution. You agree?
Agree, Your Honor.
Yes. And therefore, the Constitution should survive not only an interpretation of the past in 1986 or 35 or even the 1900s, but it should also be given what the text can bear, given what the text can bear. In other words, we cannot change the words, but the interpretation should not become too absurd because we cling to an interpretation that is already in the past. You agree?
We agree, Your Honor.
And that is what is meant by constitutional interpretation in general. You agree?
We agree, Your Honor.
Yes. And the various starting points of interpreting the words and coming out with a construction, the meaning of the words, given facts, is what we call the interpretative modality of each member of the court and the court in general. You agree?
Agree, Your Honor.
Yes. So we are now confronted with a challenge as to whether the legislature correctly interpreted all the words in the Constitution relevant to the statute at hand, and therefore say that the statute or various parts of it are consistent with the Constitution. You agree?
Agree, Your Honor.
Yes. But of course, we're different from the Senate or the House, correct?
Yes, Your Honor.
Yes, and for them, they hold hearings in aid of legislation. Is that, you agree?
That's correct, Your Honor.
Yes, in hearings in aid of legislation, I think they have a better advantage because they can call resource speakers. They can swear resource speakers. And even though the speakers will state facts as well as opinions, they are allowed to do so because they are to craft legislation in order to address present conditions. That is correct?
That is, Your Honor.
Yes. And the courts are usually designed in order to be able to come after, not in order to be a third chamber. So we don't hold hearings in aid of legislation, but in order to have the specific facts already committed, already done. Using that, interpret the words of the Constitution and check whether the speculations or the foresight by the Senate and the Congress and the President was correct in relation to the Constitution. You agree?
We agree, Your Honor.
Are we not now holding hearings in aid of legislation? Do we have specific facts in this case?
Your Honor, specific facts, Your Honor.
We have specific facts now in this case.
Your Honor, it is the submission. That is why it is our submission, Your Honor, that the petitioners have no locus standi, Your Honor.
Yes, I was just helping you to say that.
Yes, Your Honor.
So do we have specific facts in this case? None, right?
No, Your Honor.
Okay. What about the newspaper report about the spokesperson of the National Task Force to End Local Communism? Is that a fact in this case?
No, Your Honor. We submit that it is not a fact in this case, Your
What
Honor.
about what happened in Southern Luzon, the Bloody Sunday? Is that a fact in this case?
We submit that it is not, Your Honor.
What about community pantries? Is that a fact in this case?
Again, we submit it is not a fact in this case, Your Honor.
Oh, so has anyone been arrested? Has anyone been arrested?
Yes, Your Honor, for violation of the ATA of 2020. Yes, Your Honor.
And they're part of the 37 petitions here?
Your Honor, they are not part of the 37 petitions.
Why can we not tackle that here now?
Your Honor, it is our submission that the petitioners didn't have locus standi and that.
No. Why can we not tackle that? Please be responsive so that we can go faster. Why can we not tackle that? In principle, the concept of it, so that we have a fuller understanding and a fuller grasp of the doctrines in this case and what is at stake.
Because there are constitutional requirements before you.
Why? In other words, what is the principle behind that? In other words, why can we not just, we are the Supreme Court, why can we not just say, bring the facts here? We'll hear it here.
Because they are not a party to this case, Your Honor.
Because we are not built to do that, correct?
Yes,
we are not built to receive evidence.
Yes,
we are not received to accept cross-examination of the evidence.
Yes,
we are not built to allow due process in the hearing. In other words, objections to every question that is asked of every witness, the calling of every witness, the qualification of every witness. We are not built to do that. And there are institutions within the judiciary that are built to do that. Is that not correct?
That is correct, because the Supreme Court is not a trier of facts, Your Honor.
Yes, in fact, we constructed the courts in order to be able to have lower courts to be able to deal with the establishment of facts. Correct?
Correct, Your Honor. And
what is meant by establishment of facts?
For evaluation of facts, Your Honor.
What is meant by it? What to a lawyer is the truth in trial?
Proving the facts, Your Honor. And this could only...
Truth in trial is what you can prove in a court of law. And proof is the effect of all the evidence, correct?
Your Honor.
Yes, and it is not true with respect to the Supreme Court until and unless, number one, we can take judicial notice, and number two, that the facts have been established through evidence, correct?
Yes, Your Honor, agree.
Yes. Okay, so that is our system. So no matter how much I would like to agree, for example, with my colleague, Justice Ben, with respect to atmosphere of fear, the vagueness in some of the provisions, and no matter how much I would agree that leftist is such a pejorative term given by someone who does not understand what is meant by being progressive or leftist, no matter how much I know that ideologically and philosophically, I cannot rule on the case on the basis of that idea because I have to rule on the basis of facts as it is there, correct?
Correct, Your Honor.
Yes. So if we dismiss the current petitions on the ground, for now, that we choose not to exercise our power of judicial review, does that necessarily mean that no person more directly, materially, and substantially affected may in the near future challenge a portion, or if it affects him personally, directly, materially, and substantially, a large chunk of the law here in this court?
No, Your Honor.
So if we do a dismissal on this case saying judicial review is not warranted because in the near future, you might have a set of Supreme Court justices that simply acts on law that is passed, and someone coming here and saying the law is bad, the law is unconstitutional without the facts, and ruling upon that particular law, and saying, wait a minute, to everybody, this law is now constitutional, and sending the message that nobody can challenge. That's the danger, correct?
Yes, Your Honor.
In fact, it happened in the past, correct? In our country. In the recent past, that happened, correct?
Yes.
I'll give you a title of a case. Imbong versus Ochoa. The reproductive health law was passed, implementing rules were promulgated, and then it was challenged in this court. No facts. Yet the court proceeded to rule on many things, and we almost started to rule on the start of life. You recall that case?
Yes, Your Honor.
Yes. You recall my position in that case?
Yes, Your Honor.
The entire law is not unconstitutional because we cannot exercise judicial review, correct?
Yes, Your Honor.
Thank you. You are one of the few that has read all 90 plus pages of my separate concurring opinion in that case. Can you recite all of it? No, I'm just kidding. But the point there is that that is its danger. So in effect, there are cases where judicial review is only a discretionary power on the part of the court, a duty on the part of the court, or constitutionally inappropriate. Three categories. There are cases where judicial review is discretionary. Second, when it is a duty. And third, where it is constitutionally inappropriate. You agree?
Yes, Your Honor.
Okay. And this is basically because, again, if I will repeat, we are not a third chamber of the legislature. Neither do we have control over the president or any other constitutional organ. You agree?
We agree, Your Honor.
Yes. I specifically use the word control, not supervision. You agree that there is a difference?
There is a difference, yes.
Yeah. We cannot control, we cannot, no matter how much we ideologically differ from the president or Congress, we cannot substitute our judgment. They are tasked and they have to submit to the electorate every so often with the solutions to contemporary problems. If it works and if it does not work, we don't have to do that. We have tenure in this court. And we do not submit ourselves to the electorate to prove whether our solutions actually work or not. That's the big difference. You agree?
Agree, Your Honor.
Yes. Supervision is another matter. Of course, we do not supervise the president. But when any constitutional body or organ transgresses their power, gravely abusing their discretion, that is the extent of the quote and unquote supervision that the court may have, right?
Yes, Your Honor.
Yes. In Tanyada versus Angara, we call that judicial review, correct?
Yes, Your Honor.
Doesn't mean that we're better. It simply means that the text of the Constitution, given the facts, cannot bear the meaning that you have given to the law or the implementing rule that you have actually applied. You agree?
Agree, Your Honor.
Yes. And therefore, when we say extraordinary jurisdiction in the progressive 1986 Constitution, it does not mean that the court can do the role of the president or Congress in order to just say everything is grave abuse of discretion. You agree?
Agree, Your Honor.
Yes. So therefore, even the extraordinary situation contained in Article 8, Section 1, that we can declare null and void an act of a department of government as grave abuse of discretion transgressing the Constitution requires that there is an actual case. You agree?
Yes, Your Honor. That is correct, Your Honor.
Okay. By the way, just a point of clarification because the petitions are so varied. Okay. There are two kinds of certioraries. And in fact, certiorari is a label which simply translated from the Latin, would you know its meaning?
No.
So, yeah. Oh, you don't know. You might want to use it once in a while while you are on a date. Certiorari is discretion. That's the sole Latin meaning of certiorari. So when you say a petition for certiorari, it's a petition of discretion. A petition of certiorari, it's a petition of discretion. That's just what it means. And we put a Latin label just to say, wait, we're meaning the legal kind. There are two kinds. Rule 65, in which case it can only be used for purposes of those that are quasi-judicial, etc., based on Rule 65. You agree?
Yes, Your Honor.
And there is also the extraordinary certiorari found in Article 8, Section 1. You agree?
Yes, Your Honor.
Yes. In fact, we clarified this in a few cases. The first one where I think it was very clearly clarified is in the case of AMCO. You remember that case? AMCOW. That's a labor case.
No, Your Honor, not
But
a
it was clarified there. And would you remember who the ponente was?
I do not remember that labor case, Your Honor.
Well, the incoming Chancellor of the Philippine Judicial Academy, you might want to get acquainted with that again, because it's a very important case. Then in the case of later on other cases that came to the court, where we started to say that perhaps it is time that we have a separate rule on certiorari only for the extraordinary kind, not only Rule 65 to make that clear. Okay. But there is a very extraordinary situation where the court, even without facts, intervenes in order to do what is called not as applied interpretation, where there are facts, therefore we apply the law to the facts, but facial, which means just reading the provisions of the law.
Yeah.
You agree? Okay.
Yes, Your Honor.
And that very narrow, okay, that very narrow exception, that exception should be read as very narrow because it fundamentally alters the relationship of the judiciary with the other departments. You agree?
Yes, Your Honor.
Yes. And the canonical view is that facial review, that is the exercise of judicial evaluation, simply on the basis of the text of the law without established facts, is only applicable for issues relating to freedom of expression. You agree?
It is correct, Your Honor. Agree,
You shouldn't agree fully, because freedom of expression, yes, but a specific kind of freedom of expression. This is different from a judicial evaluation as to whether a law transgresses a constitutional provision as it is applied in an actual case. You agree?
Yes, Your Honor.
Okay. And in terms of freedom of expression, if we go back to the provision on freedom of expression, there are three things there. Article 3, Section 4. You remember that provision? So, Solje.
Yes, Your Honor.
Yes, okay. There is freedom of speech, there is freedom of the press, and there is freedom of expression.
Yes,
You
sir.
agree?
Yes, Your Honor.
Now, freedom of speech must be different from freedom of expression and must be different from freedom of the press. Correct? And the way to understand this more clearly is to go back to the philosophy of freedom of expression. You agree?
Yes, Your Honor.
Perhaps we should just go into that because you might have another way of attending to that. Freedom of expression is usually canalized into three different purposes. The first one is arrival at the truth. The second one is for the purpose of governance. The third one is for the purpose of what is called autonomy or dignity. You agree?
Agree with you, Your Honor.
Okay. So for arrival of the truth, certainly there is deliberative discussion. And usually this means speech, freedom of speech. And when within a society, it means freedom of the press. You agree?
Yes, Your Honor.
Yes, because we are trying to flesh out that exception where we can do a facial review. So I'm just going through this very quickly. Okay. Now, for the purpose of attending to governance, it is also freedom of speech, it's deliberative, and freedom of the press, more institutionally deliberative. You agree?
Agree, Your Honor.
Yes. And freedom of expression, on the other hand, is usually the artistic sense, where you have to express because that is part of your dignity as a human being. That is part of your expression of your autonomy, without which, being curtailed of that, you lose your sense of being, not being able to socially communicate with others. You agree?
Agree, Your Honor.
Yes, okay. Now, the exception to facial review is not all kinds of freedom of expression. It doesn't mean that the court will not review whether there is a breach of freedom of expression. It only means that it requires the usual, that there are facts. And this exception is when there is a chilling effect that concerns arrival of the truth and governance. You agree?
Yes, Your Honor.
Yes. Chilling effect. A chilling effect on people that will want to participate in arrival of the truth, not any truth, but truth with respect to governance. Because without that, everything else falters. Because sovereign is the biggest branch and most fundamental branch of government. The people are the most fundamental organ of government. You agree?
Agree, Your Honor.
Yes. All governmental authority emanates from them. So if there is a law that is passed to curtail their ability to make speech in order to be able to comment, in order to be able to criticize, no matter how good, no matter how bad, no matter how trollish it may seem to someone else, no matter how leftist or rightist it may seem, then the court has to act because the fundamental organ will be affected, correct?
Correct, Your Honor.
In the language of the millennials and the later generation, you are attacking the source code. You agree?
Agree, Your Honor.
Although you do not know exactly what the source code means, right? But in any case, so the point there is that because you're attacking the very speech of the sovereign, then the court will say, wait a minute, we cannot wait until there is a breach because the shaping of opinions is already affected. Is that correct?
Correct, Your Honor.
Yes.
Agree
And perhaps in some cases, there was a bit of liberality in the language, looseness in the language, where this court declared fundamental freedoms. When fundamental freedoms covered by the Bill of Rights are affected, the court can do facial review. And again, we go back to the earlier canonical danger of the court putting under its shadow all the other political departments of government. Correct?
Correct, Your Honor.
So, because the only way that the court checks its powers and is through its creation of its own doctrine. Correct?
Correct, Your Honor.
That's why there are 15 of us. There is not a single one of us. And we put everything to a vote, in order to be able to check that doctrine is too transgressive of the other departments. You agree?
Agree, Your Honor.
So there may be a fundamental right, there may be a fundamental value or a fundamental right that will be affected, but it should affect the source code. It should affect the sovereign. And there must be a clear and convincing demonstration to that effect. You agree?
Agree, Your Honor.
Before we can do a facial review. Agree?
Yes.
Okay.
Yes, Your Honor.
When do we know that there is chilling effect?
Chilling effect is something that must be some substantiated, Your Honor. A factual matter generally not, may we submit, not a factual matter generally not within.
I'll do a rough translation. Chill is to fear, correct?
Yes.
Chill, more or less, means fear. How do you measure fear?
By the discomfort, Your Honor.
What do you mean? I am always at a discomfort. I'm always at a discomfort because that's life. Life is suffering. According to the Buddhists, life is suffering. And therefore, chilling effect, when allowed to be remain as is, can become a very subjective basis for doing facial review. You agree?
Agree, Your Honor.
Yes. So maybe there should be some demonstration on the part of a petitioner, some demonstration that indeed there are chills that are happening. That not correct? You agree with that?
Agree, Your Honor.
Because otherwise, given a different government, given a different administration, given a different generation, the court can now refer to a case, maybe like this one, where the court said, chilling effect should not remain only addressed to the minds of the 15 justices, because we are also subjective. But their minds, their interpretation must be based upon a clearly demonstrable fact that has happened in order to be able to see that there is such a chill. Correct?
Agree, Your Honor.
And of course, your position is none of the petitioners have been able to meet that kind of quantum. You agree?
Correct, Your Honor. That is our position, Your Honor.
Yes. However, just looking at the law and just reading it as a lawyer, an ordinary lawyer, there are many new things, and I think my colleagues have pointed that out to you. What is meant by suspicion? Correct? I think one of my colleagues also mentioned to you the first standard that is required before there is extended detention, the detention of 14 days. Not extending it, but before it is extended. Another colleague has said, does the accused have the right to evidence? Another colleague has said, what is the atmosphere of fear, etc. So there are portions in the law that seems to be, frankly, quite vague. Even with the introduction of the implementing rule and regulation. However, you will cover in your memoranda that all of these are speculative. Is that not what you're going to put in your memoranda?
That is correct, Your Honor. And we will say that they must substantiate this claim, Your Honor.
Yes. Okay. Just a few clarification, for example. You always state that the person that can detain by virtue of orders of the ATC or to address lawless elements within this particular statute are two entities, police or what do you say? Military.
Yes, Your Honor.
Yes. So in other words, this law authorizes the military to arrest domestically, to do police work.
Yes, Your Honor.
So in other words, we are now authorizing the armed forces of the Philippines to do police work through this law.
Your Honor,
or is there a distinction?
The arrest is by virtue of a valid warrantless arrest.
Yes. And I am not there yet. I'm not there with respect to the authority of doing the arrest.
Yes, Your Honor.
Who does the arrest? So you always say law enforcers or military. And I do not wish to cover all the other ambiguities that my other colleagues have pointed out, but it seems that you are so used to or confident that it is the law enforcer or the military.
Yes, Your Honor.
You know how the 6th Infantry Battalion operates within the area of the Bangsamoro during the time that there was an insurgency of the MILF? To make an arrest, they could not do that by themselves because they were external defense forces. So what they did was talk to the police officers, go with them during their operations, and the police does the arrest, not the military. You know why? Because the military is not trained to do civilian jobs, such as arrest and build-up of cases. The military does defense. It does the coercive stuff. It does force primarily. It is the force and their force multipliers, in addition to the military, show the coercive element of the state. The police, however, are really the law enforcers in this country. They act domestically. In the United States, the military only comes in when they are requested by martial law. Not even posse comitatus, by martial law. So does this law already embed the concept of martial law?
No, Your Honor.
Still, maybe you will want to cover this in your memoranda, that ambiguity of who does the arrest, the military or the police. You know, that also says a lot about the target of this law. Because the military's mission is very clear. Who are in their order of battle? The police mission is also very clear. Who are in their order of battle? And therefore, it goes into the interpretation of this particular law. Okay. Madam Solgen, nakulong ka na ba?
Sorry, Your Honor. Not yet, Your Honor. I do not wish.
Not yet?
Not yet. I do not wish to be incarcerated, Your Honor.
Okay. What do you think? Ano kayo nararamdaman ng nakukulong?
I am sorry. Excuse me, Your Honor. Your Honor, may I beg your pardon?
Ano kaya ang nararamdaman ng nakukulong?
Fear, restraint of his freedom.
Una-una, kahit sino ka. Kahit Chief Justice ka ng Korte Suprema na hinuli ka ng traffic police officer, you feel the helplessness. Okay, pag kinulong ka, lalo kang helpless. Pag abogado ka na nakulong, and I tell you this, pag abogado ka na nakulong at may tinutulungan ka, biglang nawala yung iyong kapangyarihan. Biglang upo ka doon at nagkakaroon ka ng tinatawag na psychological trauma kahit isang oras ka lang nandun. sa isang detention center. You've seen our detention centers, correct? No, I
Yes.
do not mean the custodial center in the PNP Krame or maybe even the Kutan. I mean our ordinary detention centers. You've seen that, correct?
Yes, Your Honor.
Sitting there together with everybody else, feeling helpless, waiting for succor, waiting for your release papers to be processed, waiting for your bail money to be processed. That impacts on you, correct?
I agree, Your Honor.
Yes. And if the accusation was merely on the basis of suspicion and later on you are released, it is not true that there is no damage. There is a fundamental damage, correct?
Yes, Your Honor.
That not capable of pecuniary estimation, correct?
Yes, Your Honor.
Just as the people being arrested due to quarantine violations before, being incarcerated even during the time of COVID, there is something that happens to them, correct?
Yes, Your Honor.
So there is damage to them, right?
Yes, Your Honor.
Yes. On the other hand, when a bomb explodes somewhere else, there is also damage that is committed to collaterally to bystanders. Is that not correct?
That is correct, Your Honor.
Yes. So here, fundamentally, we look at the fundamental values of the Constitution in relation to the text of the Constitution, in relation to our power of judicial review, to weigh two things. Okay? Will we allow very light, less severe guidelines in order to detain an individual? If it were really a hardcore terrorist, maybe no problem. Because a terrorist, they're used to that. They're used to being arrested. That's part of the risk. A lawyer also stands the risk of appearing in court and appearing before a judge. That's part of that's occupational hazard. But for anybody else, an ordinary person, even a peasant leader, put into jail, it has an effect on them. You agree?
I agree, Your Honor.
Yes. And therefore, we are weighing the possibility that at least one or two or three, we make a mistake administratively without the court helping us, without a bilateral examination of the evidence, that we make a mistake, okay, in order to be able to prevent a bomb that will explode somewhere else, correct?
Yes, Your
That's
Honor.
a sacrifice.
Yes, Your Honor.
Yes, because even with all the guidelines that you have promulgated, still and all, it will be interpreted by the ordinary foot soldier, the ordinary police officer, and they will look at somebody, mukha kang terorista, leftist ka, komunista ka, pasok ka muna dito. O, 14 days ka rito, later on, may nag-habeas corpus or somebody was able to release you, you are released. But it has also created a damage. Mali pala. Hindi ka pala komunista. Hindi ka ND. Hindi ka not them. SOC them ka pala. At kahit ND ka, hindi ka pala RA. Rejectionist ka. At kahit RA ka, hindi ka Marxist, Leninist, Maoist. Marxist, Adorno ka. Marxist, Gramsci ka. Hindi ka Marxist na Joma Sison. Marxist, Leninist, Maoist. Nagkamali sila. Porque meron kang libro na Communist Manifesto, nagkamali yung foot soldier. That was the mistake. That is a risk in the implementation of the law, correct?
Agree, Your Honor.
So we weigh that in relation to, buti na bang magkamali doon kaysa may bombang mag-explode, right?
Correct, Your Honor.
It's like the age-old philosophical problem called the trolley problem, right? You know the trolley problem? Okay. The trolley problem is there are 5 people down a railroad and there is a runaway train. The only way that you can stop the runaway train from running over the 5 people is that you push a lever so that the train goes to another rail. Except that in the other rail, there is one person. And therefore, you pull the lever in order to save 5, but you hit 1, you kill 1, right? So that's a trolley problem. Okay, what would you do, Soljen? If the runaway train was going to 5 people, will you pull the lever?
As against 1, Your Honor, then...
you would pull it.
Yes, Your Honor.
Supposing the one on the other side is a justice of the Supreme Court. Against 5, would you pull the lever?
Against 5, may I respectfully say Yes, Your Honor.
Alam ko iniisip mo. Depends kung sinong justice yan. Mas madaling i-decide. Okay? But the point there is, one person mistakenly accused, having to suffer the incarceration, having to suffer the label in designation, as against the promotion of 5 individuals. Kapag nanay mo yan, pag nanay mo yon, kapag asawa mo yon, pag si Solgen Kalida yon, kasi alam ko mas mahal mo kaysa sa kanila lahat yon, would you pull the lever? Becomes more difficult, right? And the way that we look at all of this is that all of them are parang statistics sila. Pero sa totoo lang, sa buhay ng tao, pag nakulong ka, kamag-anak mo nasasaktan. Kamag-anak mo nasasaktan. And all this becomes moot for them, academic for them. The Constitution for them does not live. The Constitution for them lives when the Supreme Court says, sorry, you're collateral damage. Sorry, we cannot take care of you. That's why we are very careful in this particular case to make the right pronouncement. That if we proceed with it, that we are careful that we do not hold the hands of government for something that we do not truly understand. There are many kinds of terrorism, and excuse me, hindi lang communist terrorism yan. There is Salafi jihadism, and that's complex in itself already. And that's something that I want to ask the National Security Advisor if there is some understanding to that. In fact, I want to ask whether there is some understanding of Marxism in general. Okay, Solgen. Why is it so wrong to be communist? Is it wrong to be communist? Ask the Solgen, is it wrong to be communist? And your answer should be no. It should not be wrong to be communist. Every person is entitled to their political view. And to be communist does not mean CPP NPA. To be communist means you believe in the writings of Karl Marx and the Communist Manifesto and the Communist International. Correct?
Correct, Your Honor.
Or did you not know that? Are we going after those that we deem leftists simply because we feel them as leftists? And contrary to the opinion of others, being leftist again is a pejorative because it reflects on whoever is labeling that person. What if I told you I am socialist? Am I leftist? What if I told you that in the heart of my heart, I believe that the ownership of means of production should be in the hands of workers? Am I communist?
We should never punish an ideology, Your Honor.
No, I tell you, and I will broadcast to everybody, I incite others. Let's move towards a society where the means of production is held by the workers. Where there is no such thing as passive capital. What if I say that? Is that wrong? Again, it goes into the sophistication of understanding what it means to have an ideology, what it means to incite, and so on and so forth. Okay, let me go to another point. You're into freedom of speech, or is it the other Solicitor General?
Attorney Rigodon, ASG Rigodon, Your Honor.
Okay, can I have him please?
Good afternoon, Your Honor.
Good afternoon. I hope you're well. Okay. Now, on freedom of speech, it's not absolute, correct?
Yes, Your Honor.
Yes, it depends on the context, correct?
Yes, Your Honor.
Apart from the principle behind valorizing the freedom of speech, correct?
Yes, Your Honor.
So there are instances when whatever you do, falsity will become a falsity, correct?
Yes, Your Honor.
Let me give you an example. Epistemic bubbles. You know what these are?
I'm sorry, Your Honor.
You don't know what an epistemic bubble is?
No, Your Honor.
It is a Facebook group, for example. It's a Facebook group containing individuals that already believe on something. Okay? And what they do is they're an echo chamber to each other, saying things which all of them already believe. And because they become bigger and bigger, enticing many others to come in without evidence, they become an epistemic bubble. You know Pizzagate in the United States? Pizzagate?
No, Your Honor.
where the far right movement said that Hillary Clinton had a pedophile ring in a pizza parlor. In fact, somebody went to the pizza parlor and demanded that they open the cellar. And lo and behold, walang tao doon, walang bata. But even when they opened it, still they believe, tinago lang niya. That's an epistemic bubble, correct? No matter what you do, there is nothing that you can do to convince them, correct?
Yes, Your Honor.
Yes. We have a more laymanish term for that nowadays. Would you know what that is?
No, Your Honor.
Called the troll farm. Correct? Troll farm. Whether kanan, kaliwa na troll farm. They already believe. When they say Leonen, si Leonen ganyan yan, kahit walang ebidensya, ganyan yan. Ito, 1, 2, 3, 4. When they say ex-justice, si justice, okay yan, 1, 2, 3, 4. Regardless of the evidence, 1, 2, 3, 4. That's epistemic bubble, correct? Okay.
Yes, sir.
Now, imagine that happening to people who believe that the only way that they can have a religious rule in this society is to destroy the current situation, the current setup, and whether there are collateral damages or not is okay because their God says okay yan, or their interpretation of the God, their interpretation of the basic book says that, correct? And all of them believe in that. That's an epistemic bubble, correct?
Yes, Your Honor.
Yes. And freedom of expression there should be very limited, right? That's how violent extremism exists. That's how violent extremism comes out. When people are so addicted to social media, they only look at the algorithms produced by the computer and so on and so forth. And that is why we have to be very clear as to the kind of speech that we curtail in order to prevent terrorism. Correct? It is not all kinds of speech, but these kinds of speech that are happening. Correct?
Yes, Your Honor.
Yes. And therefore, again, maybe the need for a specific case in order to be able to see that. Correct?
Yes, Your Honor.
Yes. And therefore, that is why it is necessary to have that specific kind of speech. Kung hindi ka terorista, hindi ka dapat matakot. You mentioned that.
Yes, Your Honor.
Yes. I think it was not only the president that mentioned that. And with all due respect to the president, in 1980s, when I was myself a person working with the public interest, an activist during those times, I heard that already. Pag hindi ka komunista, huwag kang matatakot. The problem always is, sino bang komunista? Sinong ile-label natin na komunista? In fact, one of my colleagues already said that. Isn't a label already a punishment? And I think, again, you have to cover that in your memoranda. Finally, red tagging. Okay. You claim, or your colleague claimed, and I think it's the position of the Solgen that claims, it is not red tagging, it is truth tagging. Truth tagging. So when somebody is labeled as leftist, or pulahan, or CPP-NPA, you're just saying it's the truth based upon evidence, correct?
Yes, Your Honor.
Yes. But maybe government should say that we do not tag. Because every person is nuanced, sophisticated. We do not know. We're not sure. Baka sa labas ganun yan, pero sa loob hindi. Would you have imagined that I interpolated like this, Mr. Solgen? You could not imagine, right? Until I do it, correct?
Yes, Your Honor.
But to label somebody as this is to actually already deny that person of its sovereignty, to be able to participate in the field of ideas because you have already curtailed that particular individual. Okay. Again, freedom of expression. Okay. The spokesperson who wears a military uniform has freedom of expression. This is the first time that I've heard that a military person, even colonel or general, does not answer to a chain of command, does not have that discipline, and cannot be told You cannot say that because you belong to the institution. You want to say that, get out of the institution first. The same way that I cannot criticize the Supreme Court without disrobing myself and getting out of the court. You agree with me?
Yes, Your Honor.
Yes. And for so long as you are in government and you speak something, and if that speech is made in relation to an executive agent, and there is only one executive, then don't you think that's also the voice of the executive? Unless the executive says, be quiet, hindi mo pwedeng sabihin yan, hindi ko palisiya yan. Gusto mo sabihin yan, you want your personal freedom of expression, you go out of government first, correct?
Your Honor, with respect to the attributing that statement,
No, your excuse was he had freedom of expression. You cannot stop it.
Yes, Your Honor.
But I'm sorry, he is part of the military establishment. He is part of the executive, correct? And again, maybe our concept of freedom of expression is too liberal for those in government, but too restrictive for those outside. I do not know, and perhaps you can cover that in your memoranda. I would have gone to the specifics, but fortunately for me, my other colleagues have very ably and more eloquently than I covered many of the points during their own interpellation. Okay. Now, Solgen, I think you have to address very clearly what are the parameters for us to do judicial review. And second, given this law that appears in many portions to be a little bit vague, shouldn't we therefore have the opportunity to come in only to protect the source code, only to protect the sovereign? I think those are, for me, the more fundamental questions in this particular law. Chief, I yield. Thank you, Solicitor General. Have a good afternoon. Chief, I yield.
Thank you, Your Honor.
Thank you, Justice Marvick Leonen. It's past 5:30 or it's already 5:40 by the court's clock. Anyway, we have a setting tomorrow. So we'll adjourn the session this afternoon and resume tomorrow. And the court informs that although previous interpellations were made by other justices, they reserve their interpellation or questions to National Security Advisor Herman Henes Esperon after all the justices have concluded or completed their interpellation of the Solicitor General. So, adjourn the session.
Please remain in your respective seats while the Chief Justice and the Associate Justices leave the